The team at Olliers has huge levels of experience of defending allegations of sexual offences. They can range from allegations of rape, sexual assault, allegations that are historical in their nature, grooming offences, communications offences, offences involving allegations of indecent images. We frequently represent professionals, individuals involved in education, the medical profession, the care sector. We may act for people who are alleged to have committed offences during a relationship. We frequently act for young persons who are facing allegations. A number of our specialists deal with allegations involving trafficking and prostitution. We also have specialists who deal with applications to vary or discharge sexual offence prevention orders and sexual harm prevention orders. Following an interview at a police station, there's an awful lot that can be done on behalf of someone who's facing an allegation of any kind of sexual offence. The first thing to do is to consider what material can be obtained that may undermine or contradict the allegations that were put to our client during an interview. It's at that point that we would look to instigate pre-charge engagement with an investigating officer. And that is with a view to making representations against charge, arguing that the charging standard that governs the decision to charge is not met because either there is not a realistic prospect of a conviction or that a prosecution is not in the public interest. The kind of material that the defence would obtain on behalf of a client would vary from case to case, not only the allegation but the facts of the case, but it may include messaging between parties, whether that be text messaging, electronic messaging of other kind. It may involve social media activity. We may look at banking and financial transactions. There may be CCTV material that's relevant. There may be witnesses that can be spoken to. There could be third-party material, there could be material in other proceedings that's relevant to an offence. So there's a whole host of material that can be obtained and investigated in relation to any kind of sexual allegation. The message at Olliers is that if there's anything that you think is relevant to your defence, then you tell us, and then we will decide whether that should be put to the police during the course of pre-charge engagements or whether it should form part of representations against charge. A historic sexual offence is a term that's used to describe an allegation that happened some considerable time ago, and in many cases decades ago. These may be allegations of rape or sexual assault, maybe allegations involving children. And one complicating factor is they may be allegations governed by legislation that's no longer in force. The key feature, if you're facing an allegation of historic sexual offences, is to make contact with a specialist lawyer at the earliest possible opportunity so that you can be provided with the advice and support, whether that be during the investigation stage or if you are already being prosecuted. The decision to prosecute is made in accordance with the charging standard, which is contained within the Code for Crown Prosecutors. And under the charging standard, for a prosecution to take place, there must firstly be a realistic prospect of a conviction, and secondly, a prosecution must be in the public interest. It's the role of the defence during the pre-charge stage of the case to firstly become actively involved in pre-charge engagement with the police, and secondly, at the conclusion of that process, to prepare and submit effective representations against charge, arguing either that there is not a realistic prospect of a conviction or that the prosecution is not in the public interest. Absolutely. If you face any allegation of a sexual offence, then the Olliers team will represent you. We have a huge level of experience, and we can ensure that the right person is allocated to the right client every single time.